Thanks, everyone. Thank you for the invitation. I'm really privileged to be here and to have this honor to basically start the conference with this talk. I would assume that most of you are coming from the EU. If you're not, you're probably interested in what's happening in the European Union. So what I prepared today is basically a talk on mostly stablecoins and what the updates are on the EU level when it comes to stablecoins. So first, where I'm coming from, who I am, my name is Marina. I've been also in the crypto space from 2017. I mostly work on the legal questions, governance questions, and for the last 6 years, I have been working on policy within the European Crypto Initiative, basically co-founded the organization and led since now. It has been pretty intense, I would say, part of our work, our path. And we're going to have some pretty exciting announcements in the next months, so stay tuned as well. You can always find us on our website, social media, etc. We share updates there as well. But what we do is we basically lobby in Brussels when it comes to any questions related to blockchain and crypto. So for the last 6 years, this is what we have done, and we have been we basically funded the European Crypto Initiative the moment where MiCA was first leaked. It was not officially published, but it was leaked a week before it was published. And that's the moment where we thought, okay, this is a new draft. It's completely changing the game from what we knew before. It's happening in Brussels. It's not happening anymore in France and Germany and other countries. We need to do something in Brussels. So this is how we started. And for today, this is what I prepared for you. Basically, I'm going to do a very short overview of what and how MiCA regulates stablecoins. Then I'm going to talk about 2 challenges that we have seen coming up in the last year and a half where MiCA is applicable for stablecoins. And then the last part, I'm going to talk a little bit about predictions and how business models are changing following the changes in the laws, mostly in the EU, but of course compared to what's happening in the US. So you've probably seen this, a lot of articles, a lot of discussions, the European Central Bank being recently, I would say in the last few months, but mostly the last few weeks, very intensively thinking about stablecoins, how they are regulated in the EU. Are they regulated in a correct way? Do we need to regulate more? Do we need to change something that we have today? And what are the risks when it comes to financial stability? Of course, I would say that that might be triggered most likely by what is happening in the US and changes in the administration, the Genius Act, etc. But the fact is that right now we are in front of a, I would say, quite a challenging situation, maybe also an opportunity to review what we have done until now on stablecoins and see if any changes should happen. So first, just to start, I want to do an intro on what and how the policy-making process works in the EU. I think it's very important just for us to understand how complicated this is and also to understand how to influence laws, specifically in this case on stablecoins, if we, for example, are not happy with some of the suggestions or some parts are some parts are the ones that we would want to change on it. Yeah, we're back. Perfect. So this is one of the most intense documents that you see when you work in policy in the EU. It's called a four-column table. What you have here, it's thousands of pages of documents just before one law is finalized. In this case, it was MiCA, and that was like probably weeks before the markets and crypto assets regulation was finalized. And what you can see here is that you have a part that is a Commission proposal, so a Commission draft of the law, the European Parliament draft of the law, and then the Council draft of the law. And here it's a compromise. So how it usually works is you have this for 3 different institutions, the European Parliament, the Commission, and the Council. They each write their own version of the law, and then they come together in a trialogue and they discuss the last framework. The most important thing in this process is that the final draft can be composed only with the content that was written in the existing drafts of different institutions. So you cannot introduce new topics while you are in this stage, and this is basically the trialogue stage. This is how the EU works. This is how directives and regulations are finalized. It usually takes around 5 to 6 years. This is what happened to MiCA. And what I would say, it could be a little bit controversial, but I think that the EU legislative process is much more predictable than the one that we have in the US, that I would say most of us know or read about. Because when a proposal comes usually from the Commission, there's almost no chance that it's going to be reversed or stopped. When a proposal comes from the Commission, there will be discussions. Maybe we'll have a different version at the end of the day after those few years. But I think that when it comes to MiCA, for example, the first version, as I said, in 2020, was mostly around 70 to 80% identical to the final version that we have today, 6 years later. So if you are an investor, entrepreneur, builder, you can read the first drafts and you can understand more or less where things are going to go, and that could help immensely in predicting what type of business models will be relevant in the EU or even possible in the EU in the future. So one of the most important things when it comes to MiCA and the regulation there, I don't want to go into that. You probably know that it regulates the issuance of tokens, definition of tokens, among others also stablecoins, and also crypto as a service providers like exchanges. The goal of MiCA was to basically protect consumers, to support innovation, to look for more legal clarity, but mostly financial stability. And that's the part that is really, I would say, most important when it comes to the regulation of stablecoins. MiCA was, I would say, motivated by what happened with Libra, as you know, and what the problem was there with regulators usually was, okay, we're not sure if stablecoins like Libra would be beneficial to our ecosystem because we fear there will be problems with financial stability. And this part, this is the only article, I swear, I'm not going to talk about articles or show articles of MiCA to you anymore, but this one is important because it was introduced in this part of the process at the end of the negotiation trilogue process as a new article that never existed before. And it's just one of the, I would say, exemptions of the rules to show how important from the beginning stablecoins were. So, you know, in the process, there were even some things that were not predicted or predictable. And this article is very important because it says that non-euro denominated stablecoins, if used for payments, need to monitor their transactions if they are significant. So we do not have significant stablecoins at the moment in the EU. All of the big ones, you know, they're not deemed significant. But if they are deemed significant, they would need to monitor the number of transactions and the volumes used for payments quarterly. And if they exceed those volumes, you see here 1 million of transactions, 200 million in volume, they would need to stop issuing the token or submit a plan to reduce the use for payments in the EU. I will not comment this. I think you're knowledgeable enough to understand how problematic this part is, but this is part of MiCA, and again, this was introduced in the last stage of the negotiation processes. This is the whole story of MiCA, the timeline, how it happened. So the first draft, 2020, the first trilogues starting in 2022, and then the whole process until today. What happened in between was the most important is when it was published in the official journal, 2023, and then later on applicable when it comes to stablecoins, June 2024, so 1.5 years. In between what happened, a little bit of quite important documents issued by ESMA and EBA on the basically details of application of MiCA, standards and different quite detailed, I would say, rules on the application. And what I will be talking about later, what is really important, is that ESMA published a Q&A in Q3 2025, and this Q&A is basically the topic of the discussions and articles that we've seen in the last few months and weeks. Q&A is an institute where anyone, even you, can go to the European Commission, ESMA, and ask a question that relates to MiCA or any type of regulation that you deem that is not clear enough. So anyone says, okay, I'm interested in staking, I want to learn more if MiCA applies to staking, I will ask ESMA if this is true or not. The answer that they give is pretty important because it's not really law, but it's basically seen de facto as a law and will be followed by other authorities. Well, I mentioned staking because it did happen for staking. Someone asked a question, Q&A, if MiCA regulates staking, and the answer was it does regulate if it's custodial staking. If it's non-custodial staking, it does not regulate staking because basically non-custodial activities are not regulated by MiCA. So going back to how we define stablecoins in the EU, we do have two different definitions of stablecoins. One is the asset reference token, the other one the e-money token. This is important because they are a little different, and you can see the definitions here. Basically, the e-money tokens is linked to one fiat asset. The asset reference tokens can be linked to different assets or a combination of those. And why this is important, that was published by Patrick just yesterday. He's doing these reviews on what's going on with MiCA and stablecoins mostly. It's important because we have no asset reference tokens today in the EU. They're not regulated. They have not been registered, or they've not been issued officially in the EU. So there is a challenge with asset reference tokens. They usually are pretty hard to comply with the rules when it comes to asset reference tokens. But we do have a lot of e-money tokens and e-money issuers, 17 authorized e-money token issuers, and 25 authorized e-money token, basically stable coins. It's pretty, I would say, a nice list. And that all happened in the last year and a half. So what is the challenge with asset reference tokens? As I mentioned, usually it is much harder to comply. There might be different, I would say, feedbacks that national competent authorities, like the authorities that are in each member state that are basically supervising MiCA, might also give. That's something that I think it's not like a basic knowledge that everyone knows, and of course we will try to kind of give rules, give standards in order to align the definitions and to try to make I would say, the understanding of national competent authorities the same when it comes to MiCA, but there's 27 of them, as you know, and plus the 3 in the European Economic Zone. There's 30 different authorities that are supervising MiCA. They're giving licenses to anyone that wants to issue stablecoins. And so you can imagine what type of challenge that is to basically make all of them understand MiCA in the same exact way. You've probably heard about the Athena case. Maybe you haven't, but the challenge with asset reference tokens that I want to share a little bit here is, and could be linked to the Athena case, which happened in April this year. BaFin, the authority in Germany that is supervising MiCA, was basically issuing a public statement saying that Athena came to Germany and incorporated in Germany in order to get a license to issue the stablecoin that they're issuing in the EU as well. Within the process, something went wrong, and BaFin, that is also seen as one of the first, I would say, enforcement actions. BaFin issued a statement saying that Athena should stop all the activities within Germany and within the EU because the whole process of registering the stablecoins did not go as predicted. And this is where we are at. There's like no more clarity publicly that we know of. There's nothing that happened after this statement. Athena stopped their activities in Germany. I think they shut down their company that they incorporated at the time. And unfortunately, also as a lawyer and everyone in the space working on stablecoins, we would want to understand more of what happened in this case, what went wrong. Is it maybe that Athena thought that their token would be an asset reference token and they went and applied for a process within BaFin, and there were some challenges in basically complying or maybe even understanding what an asset reference token is? There are rumors that there might be some elements that are linked to financial instruments, which are securities that are not regulated by MiCA, but then you would need to go into basically understanding and following MiFID. So there's no clarity at all. There's no legal clarity for anyone working in the space. We just know that there has been the first somehow sort of an enforcement action on stablecoins in the EU, and to this date we do not have any basically asset reference tokens registered. The other challenge that we do have today is the multi-issuance model and the multi-issuance challenge. And this is mostly what the European Central Bank was very interested in and active in the last few months. The definition of the multi-issuance is such that where one entity, even if it has different subsidiaries in different countries, is issuing one stablecoin that is basically fungible within different jurisdictions. That is the case where MiCA is not going strictly or in detail into this topic. It became a topic after the Genius Act, more or less. So the European Central Bank was issuing these statements and basically concerns about what it means when a token is registered in the EU and follows all the rules within MiCA, but there is one specific thing that could happen, which is the redemption. As you probably know, when it comes to stablecoins, in the EU, if you're registered and legally issuing tokens in the EU, all your users have the right to redeem your stablecoin at any time at par. And so the idea there is that, of course, that would be something that the EU citizens would have the right to do. But in theory, because we cannot identify who's owning stablecoins, anyone from all over the world can do that. And the problem that the European Central Bank has is if there are European companies registered within MiCA, having this type of reserves in the European banks, and there is this right that we basically give to the European Union citizens to redeem the tokens within the EU. Anyone can do that, even someone coming from the US or somewhere else. What would that mean for the stability of the companies that are issuing the tokens? What would that mean for the stability of the banks and for the whole European Union ecosystem? So this is the challenge we're at right now. The question, the Q&A was asked in April 2025, I think, and for the last 9 months in Brussels, we have been debating this topic. There's no answer yet to that. There's been many institutions involved in the process. The European Central Bank, the Parliament, the Commission, national competent authorities, and there's no solution to this answer yet. We do have some ideas and some basically papers talking about that and basically saying those are all the risks, this is what we should take into consideration. Specifically, what is important is the European Systemic Risk Board issued their own opinion, I would say a month and a half ago. And what they wrote is, we would suggest for the multi-issuance to be basically prohibited and stopped. You can imagine what would that mean. That would mean that all the biggest stablecoins would not be fungible within different jurisdictions, which in a case would, I would say, would be quite problematic when it comes to liquidity, even like in DeFi, in all the other, in a way, activities that we're doing within the space. And this is something that actively within EUCI and other associations we're trying to prevent. We're trying to basically propose that as the situation that we have right now stays the same in the future, and we do not have the prohibition of the multi-issuance as of today. Again, as I said, nothing happened yet. We had multiple meetings, issuing papers, doing all sorts of activities, but we're still waiting for a response. And what is interesting here within the paper of the European Systemic Risk Board is the first thing that I mentioned, they suggested the prohibition, but alternatively, they said if the prohibition would not happen, we would want all these things to basically be included, just a moment. Basically, they suggested a few things to be included within MiCA. So almost indirectly, de facto, asking for a MiCA review and asking for MiCA to be reopened and regulating even stronger and stricter stablecoins. So their suggestion would be that the supervision when it comes to stablecoins would be automatically on an EU level, so the European Banking Authority would supervise all the stablecoins, not the local authorities. They also suggested some discussions around equivalence regimes, which are pretty important. So thinking about the rights that we have in the EU and that we give in the EU do we have the same rights as users of stablecoins in other jurisdictions as well? So can European Union citizens go to the US and redeem stablecoins in the same way as we have the right to do in the EU? And those are, I would say, pretty important things. Also in international cooperation, those discussions are going to continue in the future. The last thing that I wanted to add for this presentation is really just a short comparison to what's happening in the US versus EU. What we have seen until now, you've heard a lot about the Genius Act. First thing is that we do know that one part of the Genius Act will need to be in detail described, and the application part is still yet to be written. So we don't know in details how this basically act is going to be implemented. But the second one is, which I'm observing, and I'm sure you have seen that before as well, is certain stablecoins are not regulated or compliant at the moment in the EU, but they are existing or somehow compliant in the US. We know about Tether, but there's also, as you know, a lot of business models that have been discovered in the last few months. And I would say that I went and read terms and conditions of some of the applications here. I would say that most of them would not be possible in the EU, and most of them are not compliant with the EU laws. So unfortunately, I think what we have done with MiCA here is limiting the business opportunities around stablecoins and what we can do and build in the EU, being very strict about all the rules when it comes to issuance, and basically most of the existing business model and innovation around stablecoins happening outside of the EU. And the last thing really for today is a little bit of the predictions. I would say that in 2026, we'll see more Q&As on different topics, maybe staking, liquid staking, other type of questions. We will probably see potentially a reopening of MiCA, which means a lot of opportunities to basically do, I would say, a review of what's wrong, what would we like to change, and potentially also changing that in the next few years. We do have a new parliament, a new commission that could support that. And the last one, most likely we can expect some enforcement actions. So it's kind of a reverse from what happened in the last years in the US. Thank you so much for this. And yeah, happy to answer questions.